to the chefs and to the business men and women, to the legal counsel, to the students, and of course you, the journalists who are here. There are constitutional rights to assemble and to express our views, and our constitution is very clear on this. Article 37 says that we have the right to assemble. Article 33 says that we have the right to express our views. So what you have just heard in the preceding press conference is really citizens expressing their views. And in that spirit, I wish to also express some concerns. Summary executions by police officers or even by members of the public violate Article 26 of our Constitution that protects all of our right to life. Article 50 states that we all have the right to trial. This particular case raises two big important issues. The first is whether police officers who are suspected, and I think Advocate Omari is correct on this, that are suspected of a serious homicide, that they have an opportunity to go to court and to clear themselves of evidence that many of us have seen, even in the public domain, and is still in the international and online spaces, related back to the killing of one Jamal Mohammed and Mohammed Bukhari in 2017. He has the right to go and plead his innocence in court, and that is the right not just for Corporal Rashid, but it is the right for every Kenyan citizen. But the rights of victims to be able to determine what actually happened, what took away the lives of these two human beings, they also have their rights and their time in course. And therefore it is premature, and perhaps I could argue that the counsels for Corporal Rashid perhaps have panicked, because that chance was coming before the High Court on December the 8th. They have filed an application essentially to stop the process that would allow for the determination of who was guilty for the killing of those two men, and whether Corporal Rashid is in fact innocent of the charges that are against him. I want to raise another point this morning, which is really important, particularly for all communities that have experienced extrajudicial killings, that have experienced enforced disappearances and renditions, purely on the basis of profiling and suspicion that they have committed either a serious crime or terrorism. And the Somali community is one such community. If there is a community that Amnesty International Kenya and the human rights community have stood with over the last decade, it is this community. It is not just the killings of young Somali youth in Garissa, where we organized a march a few years ago to draw the attention of the nation that Somali lives matter. Or is it the killings in Mandari and in Eastlands and of course in Eastleigh? We have been very clear, and our record is extremely clear on this matter, that there has been a long history of profiling, intimidation and the murder of suspects, especially from the Somali community. They, amongst others, must be aware that opening the door for unlawful police action opens the door also for enforced disappearances, unlawful renditions and violence, not least the kind that we saw in 2014 with Operation Sanitization. And Amnesty probably has the most graphic history of that operation against the Somali people, the Somali Kenyan people during that time. Is the ODPP, IPOA and civil society protecting criminals? It's absurd to argue that argument. Our record is clear, whether it be the floating bodies in the Yala River, whether it be the unclaimed bodies in Garissa, whether it be the killings of Sheikh and other Muslim faithful in Mombasa, whether it be the killings in Nyeri or in Kisumu or even in Sli. Our record has been very clear. In fact, it is civil society records that demonstrate that last year over 180 people were unlawfully killed in custody. How does that attribute to essentially that we are blocking police and criminal justice? We are essentially on the side of criminal justice. This application blocks the constitutional principle that officers can behave above the law. This application blocks the idea that everybody has the right to be heard, have the right to their time in court, particularly when there are serious allegations against them. There is a reason why our courts and our laws establish a higher standard of proof. We as a country do this to ensure that no person can be condemned based on rumors, a vendetta, or even mistaken identity, or simply just profiling that they come from some ethnic group. By holding this standard, we keep everybody safe. The question I want to ask, if 3 consecutive presidents of this republic have not executed somebody since 1987, why should that power be attributed to a police officer, not even at the rank of a commanding officer, but at the rank of a constable or a rank of a corporal? My question to Kenyans is, how will we allow a culture of impunity to occur that simply any police officer, any one of our 100,000 police officers can determine that they are not only investigators, they are prosecutors, they are also executioners, and they are judges in the same human body? I think we have to take a stand on this issue. It is the right of Corporal Rashid to go to court to plead his innocence. He has good legal counsel there. Their job is to protect him in a court of law, not to whip up the court of public opinion and have him tried in the public opinion rather than in a court of law. That is the sacred oath that all lawyers have when they take their oath, which is to essentially protect and defend clients in a court of law, not in the court of public opinion. Let me address one issue, and again, I don't want to get into the court case at this moment because I think it is a criminal case. It will be prosecuted effectively by the Office of the Director of Public Prosecutions using the evidence of the Independent Policing Oversight Authority. But let me just mention one thing that I know that is a fact. Corporal Rashid was summoned 11 times to appear before the Independent Policing Oversight Authority. He did not show up once. It is not true, as you have just heard, that Corporal Rashid was not summoned. 11 times he was summoned by IPOA. And I ask you to reach out to IPOA for verification of this if you do not take the view of a third party. Allow me to stop and just say that the opportunity is there not just for Corporal Rashid to go to a court of law, to plead his innocence, to be represented, and essentially to have his day in court. It is the opportunity also for the alleged victims and their families to seek justice and also have an understanding and closure on a case that has taken 5 years to complete. Allow me just to end by saying that we, as Amnesty International, the Police Reforms Working Group, we will continue to monitor this case. We believe it is important, not because we have taken a position that Corporal Rashid is guilty, but that he has to be also accountable to the rule of law. Otherwise, we are really opening the door, essentially, for a lawlessness and a culture of impunity that I think none of us could really survive from.